Tonight, plans to end the not proven verdict as part of a major shake-up in Scots law. The reforms include trying out judge-led trials in rape cases. That's welcomed by campaigners, but there are concerns from some legal voices.
We speak to the Justice Secretary, Angela Constance, about the changes. Also tonight, police search for a missing person at a Glasgow country park after the death of a school teacher. The first people to be evacuated from Sudan arrived back in the UK, but thousands are still in limbo.
Sport defending champion Ronnie O'Sullivan is out of snooker's World Championship. And we'll have the latest from a massive match in the English Premier League title race as Manchester City lead 2-0 against Arsenal.
And later we'll speak to voice coach Evie Burnett about the toughest singing challenge she's faced so far.
Welcome to the night. Sweeping reform to the justice system, some of it upending measures that are centuries old. The Scottish Government insists it'll put victims at the heart of the justice system. But critics in the legal profession are warning of grave implications for those tried in our courts.
And we'll have that debate very shortly, but let's break down the main reforms ministers are proposing. The not proven verdict, a third option available to jurors here for hundreds of years, and it's unique to Scots law. It's now to be abolished. Amid concern, it can be confusing for juries and the public. Its impact is the same as an acquittal, and some legal experts think its scrapping could lead to more miscarriages of justice. But for Joe Duffy, whose daughter Amanda was murdered in 1992 after a night out with friends, it is a welcome step.
I can only be delighted because no other family should have to go through a not proven verdict. It should not be there.
Perhaps the most surprising change set out by Justice Secretary Angela Constance, who we'll hear from at length shortly, is one which could make it harder to secure convictions, reducing the number of people who sit on a jury from 15 to 12. But at the same time insisting that 8 of those 12 jurors must agree on someone's guilt for them to be convicted. At the moment, 8 out of 15 are required, just a simple majority.
Alongside those eye-catching reforms, there's also going to be a pilot which will see rape and attempted rape cases being held without a jury. It'll be for a judge alone to decide on whether or not the accused is guilty. Katie Johnston, who was raped in an Aberdeen park by a man who was ultimately convicted, welcomes that change.
Going through the whole experience of my night with 15 people looking at you, it's very daunting. Some people would automatically come for a case like this with a preconceived notion of what they already think's happened. So I think a judge-only trial would be a good thing.
While the Scottish Government's main opponents broadly welcome the reforms, they claim some victims of crime are being failed.
Overall, this is the right direction of travel, but it's also a missed opportunity. I think the government here could really strengthen the rights of victims and have failed to do so in this bill.
Angela Constance, just a month into her new role as Humza Yousaf's Justice Secretary, is the minister in charge of these reforms. Before we came on air, I asked her what the argument was for scrapping the 17th century not proven verdict.
Well, of course, the whole raison d'etre of this landmark legislation that the Scottish Government has brought forward is to put victims at the very heart of our criminal justice system. And we know that victims and survivors do not have faith in a verdict that is difficult to understand.
Would it lead to more miscarriages of justice, as the Scottish Law Society has suggested? And also concerns come from recent research, the Scottish Jury Research Study, which suggested it could actually incline a jury towards a guilty verdict.
Well, that's why we in the bill have taken care to ensure, as well as having our very bold proposals to improve the experience of victims within the justice system, that we are also taking a very balanced approach. It is fair to say that verdicts and jury size and majority are all closely related.
On the top subject of jury size, changing the size of juries from 15 to 12 is also being proposed, and at least 8 of those 12 on the jury would have to agree in order to make a conviction. So that is higher than before. Could that lead to lower conviction rates, do you think, as Rape Crisis Scotland has suggested it might?
Well, actually, the changes that are proposed in terms of jury size and jury majority are in relation to the justice system as a whole, because the operation of a jury applies to not just sexual offences but all offences, whereas other aspects of the bill are very much focused on addressing the long-standing concerns around the low conviction rate for rapes and other sexual offences. We know that over the past decade, the conviction rate for rape sits at 46%, and this is about half of the conviction rate for other offences. So there are very legitimate inquiries and questions to be asked and explored as to why that is, and we cannot ignore the prospect that our justice system is failing women and girls.
But are you not concerned that if you now require 8 out of 12 rather than 8 out of 15, that could lower convictions, which is exactly what you're not trying to do?
So the reforms around jury size and majority are very much linked to the abolition of the not proven verdict.
Tommy Ross Casey said today that juries were abolished in Russia and Nazi Germany. This shouldn't be happening in Scotland. Why, in your view, are juries perhaps not equipped to be sitting and listening to a rape case?
There is substantial evidence, both at home and elsewhere in the developed world, that juries, instead of just solely focusing on the evidence that's been led in court, that they are influenced by what is known as rape myths. And that's about, false and stereotypical beliefs about how victims should be acting. It's about beliefs around the expectation that victims perhaps should have reported the offence immediately or avoided the attack or fought off the perpetrator.
But is it not the case that a jury member will bring other prejudices to other types of crimes when they're making these decisions?
So again, looking at the evidence, both in Scotland and elsewhere, we cannot ignore the vast, substantial body of evidence and academic work that shows the prevalence of stereotypes and rape myths that exist within juries.
Now, you're new to this portfolio, you're the new Justice Secretary. I wonder what your view is on the recent case of the 21-year-old who escaped jail after raping a 13-year-old girl when he was 17 years old. Do you think that the judge was correct in his interpretation of the sentencing guidelines in that case?
Well, it is important that we recognise that there is a separation of powers between political powers and the independent judiciary, and that is fundamental to the rule of law in a modern progressive democracy. So as Justice Secretary, I'm not going to be commenting on any individual cases. We need to respond in ways that actually supports victims and survivors.
Well, the victim in this case, the young girl, said that she had been let down, that she felt failed by the sentencing. There was a conviction here, but it was the sentencing issue. So I'm asking what your view is on those sentencing guidelines, whether they are correct, that an under 25 should be treated differently.
So what the sentencing guidelines say, and this again is an important factual matter, is while the sentencing guidelines require the judge and the independent judiciary to have regard to the role of sentencing and rehabilitation, they also very, very clearly say that there is a role for sentencing in punishment and that public safety is always paramount.
Okay, you're also inheriting the issue of transgender prisoners in jails. What's your view on what should happen with that issue going forward?
The Scottish Prison Service have a responsibility to protect women that are in their care, and we now have arrangements that are in place that post-conviction or post-remand in custody, that people are assessed, and that if a transgender woman, for example, has sexual convictions or a history of violence against women and girls, that they should not be transferred into the women's estate.
That's for new cases, though. There are at the moment some transgender women in the female prison estate. Do you think that that's appropriate?
There is a small number of transgender women in the women's estate right now, and this is a matter, as you'd expect, that I discuss with SPS, and SPS, have a very clear risk assessment procedures in place. And what we have to be clear about, and actually this applies to all prisoners in terms of where they should be placed in the estate and how they should be cared for, is the risk. It's that assessment of risk and the risk that they present to other people.
It's not been an easy month for your party. A police investigation into your party's finances, 2 arrests have been made, although no charges brought. Is this the clean slate that you hoped it would be, that Humza Yousaf said would come with his new approach, his fresh approach?
Well, I, like all members of Cabinet, are absolutely focused on serving the people of Scotland.
But is it an easy place to be at the moment within the SNP?
It's a matter of public record that this has not been the easiest of times for the Scottish National Party, but I think I can speak on behalf of all members of the SNP Scottish Government and indeed all members of the party, in that we are focused on going forward.
Justice Secretary Angela Constance speaking to Laura before we came on air there. Now let's look at her proposals in more depth now with Sandy Brindley from Rape Crisis Scotland and Thomas Ross KC, who joins me here in the studio. Sandy, let's come to you first of all then. Just your reaction really to these changes today and to what Angela Constance had to say to our programme.
I think overall this is a landmark bill that could really transform the experience of rape survivors in Scotland seeking justice. It fundamentally implements many of the recommendations made in Lady Dorian's review of the management of sexual offences. I think the proposals are necessary and I welcome them.
And rape cases are well known to have a low conviction rate. Are you confident that these changes will change anything with that? Will higher that conviction rate?
I think that there's 2 key issues in relation to legal responses to rape. There's the sense of procedural justice, or what people's experience of the process is. And at the moment, the experience of the process is, generally speaking, awful. It causes a huge amount of trauma. People feel they've very little agency and they're not really protected throughout the system. So I think many of the measures in this bill will improve people's sense of procedural justice, and that hopefully through the specialist court, representation in relation to sexual history, other key elements of the bill will improve people's experience of the process. But we also need to look at substantive justice, so the outcome of the court case is also at least as important as a sense of the justice process not re-traumatising as much as it does just now. And that is where I have some worries. I am really concerned about the reduction in jury majority. What are the increase in jury majority? What we know is that jurors are particularly reluctant to convict in rape cases, and I think there's a real danger that increasing the jury majority could mean the overall impact of this bill, while improving people's experience of the process, could actually result in less convictions for rape. And I think, given how low the conviction rate is just now, I think that's a real concern.
Do you not trust that jurors are able to make their own judgments when it comes to rape cases, like they are in any other criminal case?
I think there are specific issues in relation to sexual crime cases, and those issues relate to the preconceptions that the Cabinet Secretary for Justice referred to from the research demonstrating, international research demonstrating, that jurors will often use what is called rape myths, so really like false assumptions, if you like, about the reality of rape. And that is not to say they are coming to the deliberations in bad faith. I think that there is case sometimes where we have a lot of sexism and racism, for example, in Scottish society. It's naive to think that jurors won't bring those attitudes to bear on trials that they're hearing. But I think often it's that its responses to rape can be counterintuitive. So people might assume that if somebody has been raped, they'll fight back, so there'll be lots of physical injury, or they'll report straight away. And that's simply not the case in the vast majority of rapes. And I think it's this false assumptions that jurors are bringing that is a real concern. That I think what we want is a system where there's a fair and objective assessment of the evidence. And what the research tells us, and my experience tells me, is that is not happening just now.
Okay, Thomas Ross Casey, let's come to you. I mean, what do you make of Sandy's comments and these changes announced today?
I mean, Sandy has to be acknowledged as one of the most persuasive advocates in Scotland, because she's managed in the space of 2 weeks to convince the new Justice Secretary that a problem exists that never has existed. And Sandy doesn't have any evidence whatsoever to support any of the claims which she has just made in the interview. Ordinary, decent, working people serve as jurors every day in our courts. They give up their families, they give up their jobs, they experience huge inconvenience to do it. And every time this subject comes up, Sandy insults those people and suggests that either they're too stupid to understand what the issues are, that they're distracted by issues which are irrelevant, that they ignore the legal directions which they're given by the judge, that they don't stand up to the promise that they made at the trial. And every time Sandy makes that allegation, she makes it in the knowledge that there has never been any research conducted in Scotland where researchers have spoken to real jurors. None. It's never happened in Scotland.
You must acknowledge, though, that the conviction rate in rape cases is low, and despite efforts to raise that rate, it doesn't seem to shift. I mean, is there not, a circumstance where we should try these changes to see if that would work?
Well, I believe that the conviction rate should match exactly the number of cases which are proved beyond reasonable doubt. That's what I think. I believe that standard has been met at the moment. Despite all the research which Sandy refers to, nobody has ever been able to demonstrate that we're not achieving that at the moment. So I don't regard it as a low conviction rate, a high conviction rate. What I see as somebody who's conducted more than 300 trials in the High Court is conscientious people who give up their time to come and try cases. And actually, I'm really, really disappointed that the justice system, the Justice Secretary, and I give her a pass because she's new to the job, comes onto national television and insults the jurors who come and serve the justice system every day of the week by suggesting that they don't do what they promised to do at the start of every trial, which is to well and truly try the accused according to the evidence. What Sandy's saying is they don't do that. They'd make a promise at the start of the trial, then they don't do it.
And obviously those are strong words you're using against Sandy there. I mean, Sandy, how do you respond to those comments?
I think they are strong words, and maybe a little more personal that I think is helpful in this debate, because I think it should be a debate about what is the best way of achieving justice for rape in Scotland while protecting the accused's right to a fair trial. And there is nothing in these proposals that would in any way interfere with an accused's right to a fair trial. The presumption of innocence is sacrosanct. The burden of proof is not going to change. And it's not me, it's like one person saying that this is an issue with no evidence, that there is substantial evidence. We've got the mock jury research that was carried out by James Chalmers, Fiona Ledrick and Vanessa Munro, which is one of the largest in the world, that did find significant issues. There's a huge body of international research looking at the impact of rape myths and jury decision making, and I think we need to be guided by the evidence rather than alarmist, if passionate words by individual advocates.
And briefly, Thomas, then, I mean, what has been the reaction ultimately to these changes amongst the profession and your colleagues? Because as well as victims, they'll obviously be the ones that will face this.
You know, we're here in the BBC, and not so long ago the BBC conducted an excellent documentary about the ice cream wars, where two people who were completely innocent served a total of 40 years in custody for crimes that they didn't commit. There's no time for us to be complacent in Scotland. People are being wrongly convicted in Scotland, and what is being proposed is that we remove some of the safeguards which are there to protect people serving time in prison for things they didn't commit.
OK. Thank you, Thomas Ross, KC and Sandy Brindley from Rape Crisis Scotland for joining us this evening.
Police